as we will discuss, one of the core areas of work for the IRCT and something called the Independent Forensic Expert Group, which is a group of 42 forensic experts coming actually from the membership, as well as external experts from outside the membership from 23 countries in the world. The group has existed for 10 years, and it is actually the only international forensic group or group available to civil society organizations around the world more openly or broadly that accepts and receives requests for support for cases. The review of documentary evidence, such as photographs from protests, videos, other things, sometimes, review of testimonies from individuals who are in detention, photographs, different kinds of issues, and the medical legal evaluation, both in person as well as remote, of alleged victims of torture to support their claims, both to support legal claims as well as to support advocacy. How is forensic interpretation different than regular human rights documentation? Some of you may have seen about a year and a half ago, the IRCT released a report reviewing 50 random cases of about 2,000 cases of alleged torture and ill treatment that was documented in Belarus. I guess everyone has seen the news about Belarus and the protests that occurred subsequent to the elections, or the flawed elections and the re-election of the current, dictator, strongman. So we were asked by local NGOs to review 50 cases, randomly selected of a pool of 2,000, and provide a forensic expertise on them. What does that mean? That means the first level, Djordje and I, and he will speak more in a little bit, but Djordje and I received case files from these 50 cases. What was in the case files? They were interviews, right? There were medical documentation. So many individuals following release from prison and beating went to their doctors and got doctors' reports. Many of them were severely injured. They got other medical records, so on and so forth. We also received some videos, and we received some photographs. And we were asked to sort of review these. So what did we do? Well, the first thing, obviously, that any NGO would do is to review the documents and to compare and contrast all of the stories, right? So what happened in each of these 50 cases? What do we see? What are the patterns? Okay, 80% of, or 90% of people were being detained across 11 cities in 15 different detention facilities. 40% of them alleged that they were suspended, that they were tied and hung or suspended, right? 80% of them were beaten, right? This sounds very normal. Like a regular human rights report. 20% of them were electrocuted. People complained about what types of injuries. They were bruised. They had, many of them went to see medical support. 15% of them were hospitalized. Okay, so that is the first level of, let's say, interpretation or analysis that we conduct as a forensic expert. Now, what is the second level of forensic evaluation? So in each of the individual cases as well, and I think this is where, there are two different levels. This is where it departs from regular human rights documentation. The first is that in each individual case, we conduct an assessment of the consistency between the individual specific allegations and the existing evidence, right? So in each individual case, the forensic assessment adds to the, let's say, the weight of evidence or the credibility of an individual specific story. So we can say, okay, we have these 50 cases. There is this kind of similarity between all of their stories. There's this kind of similarity between all of their allegations, right? But now in 80% of cases, for example, there is a high level of consistency between the evidence presented to us, both the documentary, right, the medical records, photos and other, and even within the internal story itself, there's an internal consistency that provides strength and evidence from a scientific perspective to the individual story. And in 85% of these stories, I think it was, there's a high level of consistency. And 15% of them, the stories are still consistent, right? So that is the second level of, let's say, forensic expertise, and where it departs from regular human rights documentation. And then from that, there's a third level. What is that third level? The third level is a assessment of all of the evidence together. Now, why is that valuable? Because based on an assessment of the evidence, right, we can look at all of the photographs, for example, separately, and together. We can look at all of the types of injuries, and based merely on the evidence and injuries, then we can make determinations about the pattern and practices or the policies that may be in place. Because, for example, with the Belarus report, we can say that, okay, in 15 detention centers across 11 cities, looking at the injuries that we see, right, the patterns of bruisings are actually virtually identical, right? So each of these individuals, these 50 individuals, had a specific pattern of bruising, actually across their backside, their lower thighs, that is identical. What does this demonstrate? This demonstrates a specific systematic policy of torture and ill treatment, right, that is learned by police stations in Belarus across 15 detention centers across the country. We can then make determinations, we can make statements. Actually, the finding of the report was that there is compelling evidence of a coordinated policy and practice of systemic torture, right, based on the physical and psychological or the documentary medical evidence that exists, right? So even without knowing, right, the first level of interpretation was comparing all their stories, and the third level of interpretation is comparing all of the evidence. And even without these stories, in fact, without the allegations, we can understand what the similarity between the stories and what is being told. And so that those are really the three different levels of or forensic perspectives that we can take to evidence that is presented, right? Which makes it, and that's what we mean when we say forensic expertise or forensic evaluation, and why it adds something to regular human rights documentation and human rights investigation. I'll give you an example. In March of 2018, the Independent Forensic Expert Group, we actually conducted medical legal evaluations in Senegal of two journalists, two Gambian journalists who had fled there, right, from Gambia following torture to Senegal, and had been living there for over 8 years. And finally, 8 years later, they decided that they wanted to file a case to the Economic Community of West African States Court of Justice, the ECOWAS court. So we were asked to do a medical legal evaluation. The question is simply, tell us if they've been tortured. Okay, was this person tortured or not? Do these photographs show that they were tortured, right? But the reality is the value of a medical legal evaluation is much more than, or should be much more than, telling us if the individual was tortured or not. So, for example, with this ECOWAS case, the purpose was two things. Why did it take this individual 8 years to finally file a case? And how do we demonstrate that he's still tortured, even though the guy's already living in Senegal, which is, right, by most accounts, if you've been to Dakar, a much nicer place to be than in Gambia. So through the medical legal evaluation, we were able to demonstrate that, in fact, the individual's psychological state had been getting worse that he had been in Senegal for almost 6 or 7 years, 8 years, and he was psychologically deteriorating. Because of the loss of social links, right? Because of the loss of, he was a very well-esteemed journalist in the past, because of his separation from his family, because the fact that, he's often had to skip meals, right? Because he couldn't afford to eat. His PTSD, right? His psychological trauma was actually insisting, and was actually becoming aggravated, even 8 years later. We were also able to demonstrate that he had many psychosomatic issues, right? That he had many physical problems, many that seemed to be linked to the specific torture acts, but many that were not. And because of it, the ECOWAS court, as some of you, I think, know, became one of the first international courts to finally rule that forced exile is a harm or injury that results from torture, right? So the fact that one has to flee and the subsequent injuries or the subsequent trauma that one experiences, even when they are in another country, is a specific injury that results from torture and should be remedied as part of the Torture Act. So in many ways, the medical legal evaluation itself is not just about, is the person tortured or not, but it's meant to add value to and help the court and others understand the experience of torture.
So strategic litigation sometimes is not well understood from lay citizens, because it's something that it's not related to the legal proceeding taking place at the moment, but it's something aiming more to a longer term change in the society, which contributes to the fight against the violation of basic human rights. So as the IRCT, I think we are exposing what is a grave human rights violation as torture and treatment, and we use forensic evidence in our public advocacy in order to bring a longer term change also in policies and laws. It's strategic litigation. It's strategic because it's aiming at changing the laws and the policies at the international and national level, and it's asking the authorities for a change of approach, for a change of attitude. And it is strategic also because it's not affecting only one victim, but is affecting a broader group of victims. And a successful case of strategic litigation of exposing the crime committed, it's contributing, or it has a positive effect on the community itself. So there are we prepare a strategic litigation file, we generally expect to have three major impacts. Like the first one is aiming to grant justice to the survivors of the human rights abuse suffered, and also that an acknowledgement from the court that the basic human rights have been violated, and this might come as a public apology from the authorities, as a monetary compensation to the victim, but already the acknowledgement of the violation of their basic human rights is an important point and an added value for the victim. The second impact that we might identify when using this litigation tool is the effect on the community, because having a positive outcome from a legal proceeding involving torture survivors might help other torture survivors to speak, to expose what they have already suffered, and to denounce the behavior of the authorities, bringing then the bigger change on a larger scale in the community affected by the human rights violation committed by the states officials, by previous states officials. Also, with the strategic litigation, sometimes when we think about the strategic litigation only in terms of national court or national boundaries, strategic litigation in the view of the worldwide fight against torture, it's also something that can contribute to other NGOs, to other medical centers working in the fight against torture, as an example that a case has been brought before a court in a given state, and the survivor has received a public apology, a compensation from the state. So it will be also a kind of push from other CSOs or medical centers working in other countries to use the strategic litigation tool. So it the strategic litigation can also contribute to strengthen the full movement worldwide in the fight against torture and ill treatment, and also to heal the survivor, or to provide to establish a worldwide dialogue among survivors to discuss what they have suffered, and to do not feel alone with their suffering.
In Nigeria, for example, the Evidence Act says something that it also aligns itself with one of the provisions of the UN Convention Against Torture, Cruel, Inhuman, and Degrading Treatment. That Evidence Act is saying that every person who had complained or he had proved that the evidence that is had against them, either confessional statement or whatever, was gotten through duress, through torture, through acts of duress, that evidence will not be admitted in court. So whatever usually happens that in that court, once this allegation has been made, all the matters end and they begin to start off what is called trial within trial. So it goes on another process, which is trying to prove was torture actually carried out. And I think that this is also another thing, because the more we can be able to strengthen this process and that early contact can be made, it becomes very helpful to also be able to make sure that these victims are actually being supported. And I believe that as time goes on, when the perpetrators begin to understand that once they are torturing people, that any evidence that they are getting, any so-called confessional statement in court they are getting, will not be accepted more by court, and this will make their cases to fall.
Can I add one thing before we move on? From my personal experience and from, for instance, GCRT's work with the IFAC and the assistance we have received, these reports are also a very powerful tool for advocacy and also for education, to inform the judges, to educate the judges about the nature of trauma, for instance. Currently, after several cases, we have been approached by the body in Djordje that investigates crimes committed by the law enforcement, basically inhuman treatment and torture committed by the law enforcement, to provide them training on the nature of trauma, and why prosecutors have approached us to provide them with training. To basically, we have been developing a process of trauma-informed access to justice, to structure the process of investigation when the rights of detainees have been violated, also in other cases, so that the process, the questioning on the one hand, and also the procedural issues are victim-centered and take into consideration the nature of traumatic experiences, the neurobiological reactions, etc. So it's a very powerful, and it all started with individual reports or individual cases. So it's a very powerful tool for advocacy and bringing in this education into the justice system.
the independent forensic expert group. So what is it and what's the value of it? So like I mentioned, the independent forensic expert group is an entity. It's 42 individuals, 42 forensic experts, and these are some of the most experienced experts in the world on the documentation of torture. This is all of the principal drafters of the Istanbul Protocol. As many of you know, the UN manual on the investigation and documentation of torture, so the key international standard, which was just revised in June. And, you know, most of us are part of the, have been part of this project or been leading the project. This is, you know, this includes former chairs of the Committee Against Torture, a couple of special rapporteurs, a couple heads of training for the ICRC, the current scientific head of the Scientific Advisory Board of the International Criminal Court. It exists as a body. So when it issues opinions, it doesn't issue them just as individual experts. It issues them as a body of 42 experts who have collectively evaluated over 50,000 victims of torture, right? Who have collectively actually issued and published over 2,000 medical, legal, or forensic scientific articles, who have collectively actually conducted 1,900 trainings on the Istanbul Protocol around the world, who have a collective experience of, I believe, 600 years in the documentation of torture.
So we have different backgrounds, and we are not as a forensic doctors doing assessment of psychological aspects. So for that purpose, we use psychologists or psychiatrists. And unlike that situation, so psychiatrists and psychologists, they are not looking after injuries. So we work in a team, and that's the essence of Istanbul Protocol. So because you cannot separate physical and the mental aspect of one's well-being and health, of course. This map needs to be updated, as meanwhile we have pioneered some more countries, but it's even visible from the map. These countries that are colored has been visited by by teams of the IFEC members so far, and the number of expertise has been provided, and they were submitted. Medical legal reports were submitted to national courts, but we also tend to focus on cases that are going to be brought into the attention of regional and the other mechanisms for combating torture and for providing justice to victims of ill treatment and torture. And we also do, and I'm inviting you to find some of these articles. We are preparing statements, like you can see here, on conversion therapy, anal examination, etc., etc. And we are publishing these statements in a peer-reviewed esteemed journal of torture prevention and forensic medicine. Why we are doing that? It's also the way to update and to put a sort of to gather the existent knowledge and to do a research on the topic and to present it in a comprehensive manner in one article, which can be then used also to support some of the positions of the IFEC, but not only IFEC, but the other forensic doctors or human rights activists who are facing similar problems, regardless if they are living and working in Africa or in Europe or in some other continents. And what we are also doing, for instance, it was 3 or 4 years ago, it's coming to be 4 now, I was myself a member of the IFEC team who had visited Uganda for medical legal reporting. So we have examined several people who claim that they have been ill-treated. But we used that opportunity because it was a very, very long way, and of course it was a very expensive operation. I mean, all these logistic costs. And then we took that opportunity once we were in the country to provide some training to local NGOs, members of the IRCT, but also to raise awareness and to do some advocacy. So that's way to economize and then basically to kill two animals with one shot, which is also good. What we can also, and what we are also doing, these are desktop studies and consultations. So if you have a problem or if you are not sure how to let's say manage situation or problem that you are coming across in your activities, you may feel free to contact the IFEG either directly or through the IRCT or local IRCT partner. And then certainly you will have a response. And if we can help, of course, we will do assessment and some recommendations, like in this case, in which Human Rights Watch had approached us, to provide to provide consultations on situation in Brazil regarding police killings on the streets. I will be ending this presentation again with the figures, which are really we have to be proud of, and you can see here from this slide what we have done in figures, so in terms of evaluation of victims, testimonies, papers that are published, and so on and so forth. And we have. It's not only because James is with us, but we should never give up, So, and this is how we are living our professional lives.
In 2018, in March, the ECOWAS court, right, that you see before you, issued a statement or issued a judgment in a case of torture victims that we assessed that had escaped from Gambia and were in exile in Senegal. And in this decision, where they awarded actually damages to these journalists who were tortured and abused by Agomoh in Gambia, the court actually became one of the first courts to acknowledge and to state that being forced to be in exile was an injury and it was a harm that should receive reparations because of torture, right? That this individual specifically suffered because he was forced to, torture forced him to escape. And his life and any injury or suffering that he experienced while in Senegal, right, not having a job, being away from his family, in fact, having worsening PTSD, was a result of this torture experience. In fact, this court was one of the first to recognize that being in exile is an injury caused by torture. Now, we have two newspaper articles. You may have seen these. Actually, in March 2021, these were issued. And they were issued in the case of a woman called Nazanin. She is a British British citizen of Iranian descent and an NGO worker. She went to Iran to visit her family in 2016. Right, she actually brought her young daughter, who was a baby at the time, to visit her parents. The Iranian authorities arrested her. They tried to basically force her to become a spy. She refused, and she was imprisoned for many years. And there has been a lot of diplomacy over the last 5-6 years in which she was imprisoned to try to get the UK government to pressure the Iranian government to release her. All of this time, the UK government refused to call her treatment at the hands of the Iranian government torture. They said it was unfortunate. They said maybe she was being ill-treated, but they refused to call her experience torture. The IFEG, the Independent Forensic Expert Group, was asked to conduct a remote medical legal evaluation of her over several days while she was at her family's home. And we issued a report, which was presented to the government and made public. And here you see that suddenly on the front page is a discussion about how she suddenly reveals 5 years later that she was tortured in Iran, as if no one really knew before. And we have an opinion piece also that states very specifically the government needs to redouble its efforts to secure Nazanin Zaghari-Ratcliffe's release following new evidence that she has been tortured while a hostage in Iran. Right? There was no real new evidence. Right? She had been talking about her experience for the last 5 years. Right? She was brutally tortured, threatened, abused. She lived in deplorable conditions in a Iranian prison famous for poor conditions where political prisoners are being kept. But still, the government refused to accept it until we were able to issue a comprehensive evaluation, right, which suddenly they call new evidence. Right, so that's I guess the second point I was hoping to make. The forensic evaluation really is about pulling together and creating a picture of the torture experience, and creating a real understanding that is, in fact, difficult to ignore for both courts and governments and public opinion.
So I think that one of the critical issues that we found is that evidence is very powerful. And anytime we're able to capture this and bring that to bear in our advocacy, it makes our advocacy quite strong. So it's no longer the fact that you are speaking because you want to speak, or you are asking that the country should stop torturing, or you're mentioning that victims should be rehabilitated and supported or compensated. It's not just because you're saying it because you feel like saying, but you have a proof to show for it. Now, we have about 173 countries or state parties that have keyed in onto this. And I think maybe about 22 more state parties that, needs to join to have universal, ratification of the UNCTAD, okay? So one thing is about signing and ratifying a UN convention, or indeed in a law. The other thing is, what are the key steps that have been taken to implement? And I find that over the time, many countries, many member states of UN have failed to have this process of making sure that the implementation of what has been signed is really the issue. And I think it's really done. So I think that documentation provides us a very important process to be able to actually hold the country accountable, to be able to say, this is exactly the proof of what has been done. And this is actually what we can argue in terms of what will be the response of the country in terms of when we can show pure evidence as to something that has gone wrong. I also think that beyond this documentation helping us to be able to deal with the individual cases in terms of the kind of rehabilitation that person has, it is also something that provides opportunity for us to look at what the trend is, what are the trend analysis, and this becomes very powerful when you are dealing with the issue of advocacy. That you can say that over this particular period, we were able to find out that this issue was happening more with perhaps persons of a particular age group, or persons of a particular socioeconomic class, or persons who are located or in a particular area. And we can say that this is actually happening, or the perpetrators are mainly more persons who are based, maybe the police or any other. So I think that when we are able to find this trend, and it then gives us the tools that we can take on and then move on our advocacy. For example, in Nigeria, we have both the Senate and the House of Representatives to say to them, and within that, you also see committees that are in charge of human rights committees that are in charge of maybe reformatory institutions. And we have found that each time we come for those platforms and we're able to give concrete statistics, concrete evidence, flowing from clear documentation that we've made, it works like, if I must use the word, like magic. So I think that this is a very powerful tool that we should not ignore. But you can also use it in terms of raising awareness with key professionals. We had a virtual session sometime last year, and we had doctors who had signed into that virtual session. And again, by the time in one of the sessions that we started discussing some of these issues and began to say some of what the evidence that we're getting from the field, we realized that some doctors began to then open up to say, this is what we are finding out in our day-to-day work, which aligns with what you are saying. And it was easy for us to have many of them sign up to serve as volunteers, okay, into the scheme. Now, I also would like to mention one other thing in relation to how powerful this can also be. How powerful you can be able to use some of these tools to be able to make certain levels of advocacy. So it is not beyond the points I have mentioned. I also find that even when we are doing clearly public awareness, which I've also found that oftentimes the government agencies will not do much until they see that there is a media engagement on this. And what did we do? We had a network of journalists. This network of journalists, which were picked from relevant desks from a different media houses across the country. So we had a system where, first of all, we did the training for these journalists. And the second level, what we did was we started producing fact sheets between 2 and 4 pages on different issues. But this fact sheet also contained certain statistics, of course, coming on from trend analysis and all that. And of course, within those statistics, you are not being specific. You're not going to mention any direct victim. You are looking at mentioning the trend. You are looking at mentioning the key things you are seeing without necessarily mentioning any individual victim. But that was providing information to these journalists that they are now using to write stories they were using, and to kind of push a lot of information out there. And what we were doing was to increase the quality and the frequency of media reportage on these issues. Now, what the journalists were doing was that the stories and features that they would do for that period will focus on the theme of that particular month, or that theme, which is the theme of the fact sheet. So you find sometimes 5, 6, 10, 11, 12 of them in different formats using that. What that was doing was increasing the level of awareness on this issue out there to the policymakers.